So Denise will begin. Yes, perfect. Um, so hi everybody, my name is Adam Prizio. I'm a staff attorney with the Office of the Healthcare Advocate, and it's my pleasure to welcome you to today's Lunch and Learn, Surprise Billing and the No Surprises Act. Tell you a little bit about the Office of the Healthcare Advocate. We're a state agency. We were created in 1999 as the Office of the Managed Care Ombudsman. And an ombudsman is sort of a public advocate within a system. But because not a lot of people know what that word is, and because they wanted to amend our duties a little bit, in 2005, we were changed to the Office of the Healthcare Advocate. Who we are is a staff of nurse consultants, attorneys, paralegals, and other professionals who assist Connecticut consumers with health care and health insurance. That means a lot of different things. One of the more common ones that it means is if your doctor orders a procedure and your insurance says, well, you don't need it, or they order a prescription and your insurance says, well, you got to try these 3 other prescriptions first. You have the right to appeal those decisions. And sometimes the law or sometimes the facts support a decision that's different than what your insurance has told you. Sometimes it doesn't, but in any case, you can appeal those decisions free of charge by contacting our office. And we can help you write the appeal, put together the medical records and so on, and take you through the process. So today we're going to talk about surprise billing and the No Surprises Act. This is a piece of legislation. Well, there's 2 pieces of legislation. One is Connecticut law, and one is a federal law. The federal law took effect last year, but it's still sort of new, and I felt like it was worthwhile to go over what it does and what it is. So the first thing you need to know is that a surprise bill is a kind of balance bill. We're going to talk about what that is. A surprise bill is a bill for non-urgent services provided by a network provider at an in-network facility. So what does that mean is, you go to the hospital not because it's an emergency, but because you have a scheduled service or procedure. And while you're there, and the hospital is in your network, and while you're there, a provider, a doctor, a nurse, an anesthesiologist, a radiologist, somebody touches your case, provides you some service, and they're not in network, even though the hospital is in network. And you didn't choose them. You didn't say, yeah, I definitely want Dr. Jones, who's out of network, and I don't care. You just said, I'm going to the hospital for this procedure. Connecticut law defines that as a surprise bill. And a surprise bill is important because, in general, out-of-network providers can balance bill you. We'll talk about, I'll give an example of a balance bill on the next slide, but a balance bill is a bill for money other than your cost share. We'll talk about what that is. But your cost share is your deductible, your copay, or your co-insurance. So if they're charging you for more money than that, that's a balance bill. And many out-of-network providers are entitled to charge that to you. But if your balance bill is a surprise bill, then they're not. So here's how this works. Ordinarily, you go to a provider, and if they're and there's the 3 columns here: the provider charge, and it's broken up by whether the provider is in network or out of network. Let's say that the provider charges the same amount. They charge you $150, just to use a kind of a round number. And you submit that to your insurance, and your insurance has a discount that they apply. And that discount, when it's an in-network provider, they've agreed to accept the discount. That's one of the reasons why you save money as when you go to an in-network provider, is because your insurance has had negotiated a discount for you. Then and we're in the middle column here. Your insurance will pay, they've discounted it by $50, so you have $100 left outstanding, and that's what's sometimes called the allowed amount. Then let's say that your insurance pays 80 of that $100 because your plan calls for a 20% co-insurance. That's your share, right? Your share of the $100 is 20% up until you meet your maximum out of pocket. So your cost share is 20%. And then your provider, if you go down a little further, is not allowed to balance bill you. The reason why is because they've agreed under their contract with your insurance that they can only charge you your cost share. So your total cost there is $20. We'll go over to the third column where it says out of network. And let's say that the first two amounts are the same. The out of network doctor is charging $150. Your insurance, they don't necessarily pay the full amount that the doctor charges. Even when it's out of network, they still have some sort of a formula or a calculation that they use to decide what's reasonable, even when an amount has not been negotiated. Let's say that $50 is the discount there. Let's say they've decided that $100 is what we pay for this procedure. So they discount $50 off. They pay $60 because typically you have a higher co-insurance. You owe more. You owe more as a percentage when you go to an out-of-network provider. It's not much more, right? In this case, it's $40 versus $20. It's $20 more. So you'll get an explanation of benefits from your insurance that says you owe $40. But your provider is allowed to add back in that discounted $50 that your insurance has kicked out. They're allowed to, and that's what's called a balance bill. So your total here, it's not just $20 more, it's $70 more for a total of $90. And if you go to a regular old out-of-network doctor that's not a surprise bill, you like Dr. Smith, he's not in network, you want to see him anyway, Dr. Smith can add back in that insurance discount if he's out of network. So that's what a balance bill is. And then a surprise bill is a kind of balance bill where they're not allowed to add that amount back in. So that's what you're saving when you under the surprise bill laws. And that's what we'll talk about here. There is Connecticut has had a statute about surprise billing for a long time, and it is pretty effective at addressing this issue for providers in Connecticut and for insurance plans that are regulated by the state of Connecticut. So, and this is the text of the statute. It's kind of legal jargon, and I don't know that I need to read the whole thing, but it says essentially what I just said. A surprise bill is for services received by an out-of-network healthcare provider during a service or procedure performed by an in-network provider, sort of when the insured did not knowingly obtain the services of the out-of-network provider, right? It also, and I won't touch on this a lot, but this does come up sometimes. You should be aware of it. A surprise bill is also when a laboratory that's out of network receives, does your labs, right? Your in-network provider sends the sample to an out-of-network lab because they were the one that was available, or because they have some sort of an agreement between them, or they were convenient. But if they're out of network, if the lab is out of network, but the doctor who ordered the lab is in network, then that's also a surprise bill. The Connecticut law is clear that not every balance bill is a surprise bill. If you, as we talked about, if you knowingly elected to obtain the services of an out-of-network provider, that's not a surprise bill, and you don't have the protections. The out-of-network provider can still bill you. So it really is, I didn't know. I did what I could as a patient to get treatment at an in-network facility from in-network providers, and I did not know that this was going to happen. You're protected in that case from balance billing. Um, and this is where it sort of limits the insurance company. It says, with respect to a surprise bill, the insured shall only be required to pay the applicable co-insurance, co-payment, deductible, or their other out-of-pocket expense that would be imposed if they'd gone to an in-network provider. So that tells the insurance company you can't impose a higher cost share, right? So you remember in a couple of slides ago that it was a 20% cost share for in-network versus a 40% for out-of-network. With a surprise bill in Connecticut, it's got to be the same cost share. And it further says that the health carrier has to reimburse the out-of-network provider at the in-network rate. So if you remember, there was the negotiated fee, and then there was the sort of discount. And in our example, they were the same amount. But sometimes a carrier might say, well, we only want to pay 80, and we don't, there's no reason for us to pay the 100 that we would pay to an in-network provider. They can't do that. They have to pay the same. And the last piece of the Connecticut statute is section 20-7F, which this applies to providers, right? Everything in the previous two slides applied to insurance companies. It told insurance companies what to do. But then if you remember, it's the provider who has the right to charge the balance bill with if they're out of network. Excuse me. So General Statutes 20-7F limits that right. It says it's an unfair trade practice for a healthcare provider to charge other than a co-insurance, co-payment, deductible, or other out-of-pocket expense for, and then there's a couple of things here, a facility fee, emergency services, which are not a part of this presentation because that's a separate, it would take too long. Or a surprise bill as defined in the section that we just read. So this section, so where the previous section told the insurance companies what to do in terms of how much they can pay and in terms of how they can administer a cost share, this section tells the provider you're not allowed to bill that extra discount. You're not allowed to bill it back to the consumer. I often have to use this slide to talk about types of health coverage when talking about the law, because there are a handful of different ways that people can have health coverage in Connecticut, and not all of them are regulated by Connecticut law. So the way that many people think of is when you go out and you buy insurance from an insurance company and you pay a premium and they take the risk, right? They sort of roll the dice on how expensive it is to pay for everybody's medical services that is a member of their plan, and sometimes and if they get it wrong, they're the ones who are on the hook for it, right? That's full insurance. That's when that's what that is. And those plans are regulated by the state of Connecticut, and they are regulated by federal law. So the Connecticut statute that we just went through would apply to those plans, and those plans include some employer-based coverage, right? So your employer can go to Connecticut or Anthem or Aetna or Cigna or other carriers that I'm not thinking of, and they can say, I need to insure all 35 employees plus their families. And I want regular insurance, right? I want you to be responsible, insurance company, if you price the risk wrong. And the insurance company will sell them that product. And then this is also all of the plans that are bought through the Obamacare exchange, which is Access Health Connecticut here in Connecticut. All of those are fully insured, and that statute applies. But there are also employer-based plans, which are called ERISA plans. And those are where the employer takes on the risk, right? It's the employer who has to make sure they have enough money to pay all of their employees' claims in a given year. And the employer might hire an administrator. And sometimes the administrator is one of those companies that I just mentioned. and they're administering the plan. They're enrolling people and maintaining a network and adjusting the claims, but they don't bear the risk. The employer bears the risk. For those plans are only regulated by federal law. So for a long time, this surprise billing law did not have, people had no protection for surprise bills under these ERISA plans. The same thing is true of what are called Taft-Hartley plans, and those are plans where a person is insured not through their employer, but through their union. Those are also regulated by federal law. And then the publicly funded health benefits, things like Medicare, Medicaid, and CHIP, and the veterans benefits are generally regulated by federal law. Medicaid and CHIP are sort of an exception because those are a state and federal partnership. But in any case, as you can see, a lot of people in a lot of different types of insurance are not going to be covered by that Connecticut statute. So, and it's estimated that of the commercial marketplace, right, of people who are getting coverage through an employer, something like 6 out of 10 get their coverage not through a fully insured plan, but through one of these ERISA plans. So here in Connecticut. So that's a lot of people that don't have the benefit of the Connecticut law. So what happened is in 2021, they passed the Consolidated Appropriations Act in Congress in Washington, D.C. And part of that act was included the text of a bill called the No Surprises Act, which took effect last year for plans written beginning on January 1st of last year. Excuse me. The No Surprises Act creates what they call a floor rather than a ceiling, right? So where state protections, such as we have in Connecticut, are better than, are equal to or better than the protections of the No Surprises Act, those protections still apply to the fully insured plans the same way that they did. Now, Medicare, for instance, already had surprise bill protection, so folks who were enrolled in Medicare did not need those. So primarily, the No Surprises Act is going to add these protections to folks who are enrolled in ERISA and Taft-Hartley plans here in Connecticut, as well as assisting people in the states that don't have a state surprise billing law. So a federal surprise bill is much the same as a state surprise bill. It's where a patient is seen in an in-network facility, but they're seen by an out-of-network provider. Those facilities include a hospital outpatient department, a critical access hospital, an ambulatory surgical center, or an other facility specified by not Homeland Security, Health and Human Services. And honestly, the definition is relatively expansive. We had a case recently in which a skilled nursing facility withdrew some of its charges under a surprise bill theory. We said that essentially you are a facility under the federal No Surprises Act, and they had been charging somebody for the services of they had to hire out a nurse to come in. They didn't have enough nurses to treat this one particular person, and they hired out a nurse as an independent contractor, and she was not in network. And we said, the SNF is in the nursing facility is in network. The consumer is just lying in bed getting seen by a nurse that she didn't choose. So this is a surprise bill, and we got it written down. The plans, just like in Connecticut, the plans must apply the same patient cost sharing as if the provider were in network. So again, just like on that slide a few slides ago, you get with a surprise bill, you get treated like you're in that middle column, the in-network provider column, even if the provider is out of network. Unlike in Connecticut, under the federal No Surprises Act, patients can waive those protections, right? So we'll talk a little bit about what that is, but that's something to be aware of. And I see, I think I'm starting to see those waivers, the notice and consent forms, even when somebody is in a fully insured plan, because as you may know, if you've ever been to a doctor or provider, they just give you a stack of paper and they say sign this, and you don't necessarily know what you're signing or what rights you're waiving. So I think that a lot of places have just sort of stuck that notice and consent into there, and I have concerns about whether that's meaningful consent, but at the end of the day, it's not something that tends to get litigated. An interesting wrinkle of the federal surprise bill law is that providers and plans have to arbitrate their disputes. So if let's say a plan says, we're going to pay that $100, we think that $100 is a fair price for what you did. The provider says, why, that's nonsense. Doctor, in my experience, in the case of this complexity, I should be paid, $200. Excuse me. In Connecticut, the insurance company just has to pay the in-network rate. So they just have to show, hey, we've this is our negotiated in-network rate. This is what we're paying you. This is what we would pay an in-network doctor. In the federal system, they can initiate arbitration, and they can send their materials to an independent third party who will review them, which I think is interesting. So the last thing I want to talk about is waiver. I encourage people to be careful not to waive their rights. In practical terms, I understand that that's hard because, you're at the hospital because you want to receive treatment, and they ask you to sign something, and sometimes they even just ask you to sign that little gray box, and you don't necessarily know what they're putting that signature at the bottom of, what document that is. This is something, though, that as I say, doesn't tend to get litigated, so I don't know. I don't know that there's a practical answer to this, but in any case, under the No Surprises Act, an out-of-network provider, they can request what's called notice and consent to balance bill. They can't do it for everything. They can't do that for emergency services. They can't do it for ancillary services, which is, I don't have the list in front of me, but it's things like radiology and pathology services where, you're at an in-network hospital and they cut out some tissue and they say, gee, we want the pathologist to look at this. And the pathologist is out of network. They cannot, you can't waive your right for those, but other out-of-network providers can. They have to send and receive this notice and consent within 72 hours. And it's got to include certain things. It's got to let you know that the provider is out of network. It's got to give you a good faith estimate of the charges, right? They've got to tell you this is about how much it's going to cost you. They've got to list the in-network providers in the facility, right? So Dr. Smith is out of network and he's the surgeon, right? They've got to tell you that Doctors Brown and Jones and MacArthur are all in network and they're all also surgeons, and we can refer you to one of them instead. It has to spell out some of the pre-authorization and care management requirements. That's some of the insurance information. And it's got to clearly tell you that referral can be made on request. The law doesn't say that they won't have to reschedule you, right? So in practical terms, it might be the case that a referral is not practical given your situation, your circumstances, and scheduling the procedure. And the law doesn't really speak to that, but it does say that you can ask for a referral to an in-network provider. And they can't use the notice and consent if no in-network provider is available. So you may get people have started to see these starting last year, and folks should be aware of what they're signing away when they sign a No Surprises Act notice and consent. All right, I will wrap it up because I'm nearly to the end of my time. The state and federal protections for you are, a surprise bill is an extra cost when you see an out-of-network provider at an in-network facility without having chosen to do so. In Connecticut, for fully insured plans, Connecticut law limits surprise bills to what you would have paid if you'd have seen an in-network provider. Under federal, the plans that are only federally regulated, ERISA and Taft-Hartley, the No Surprises Act has a similar effect, but you can waive your rights. So be careful what you sign. And as always, if you have questions, please get in touch with our office. The information is on your screen, and we're here for you. We provide free of charge information, and we assist people with appealing these decisions. So that's what I have for today. I have got 1 minute for questions if people have questions. You can, I should say, you can put questions into the chat. I don't know if folks have the ability to unmute themselves.
Yeah, they can.
Okay.
They can unmute themselves.
All right, there's a question here from Owen. What if a patient did know that the service was out of network, but we're not informed of the cost difference? And I'm just gonna so under the Connecticut, if the patient is in a fully insured plan, then the Connecticut statute would apply, and the statute simply says, oh no, excuse me. If they knew that the service was out of network, then it's not a surprise bill. It's just a balance bill. If you know, it doesn't say that you have to know that there's a cost difference. It just says you have to know that your provider was out of network, and that's true of both the state and the federal laws. So it's just a balance bill. There's no surprise billing protections. Good question, though. Other questions? All right. Well, I apologize that I have to run, but I have another meeting at 12:30. So I thank you all for coming. Thank you for your attention. And please, if you or somebody that you know is dealing with an issue relating to their health insurance, healthcare, health coverage, please come our way, send them our way. Thank you. Have a good day.
Bye. Thank you.